Brilliant. All right, guys. So I've talked so much in the past 15 minutes, but I haven't said good morning. So good morning, everybody. It's so nice to see you. It's so nice to know that there is, well, at least 108 other attorneys. Well, 109 other attorneys that's thinking about evictions and that's busy with evictions right now. And I really, really, really just want to thank you for taking the time for today and tomorrow to join me with this webinar. It in one way, it breaks my heart a little to not do the eviction seminar the way I normally do it. So I can't see you guys. I can't have coffee with you. I can't ask you how your firms are. I can't ask you how you are doing. But at least I can sort of see you. And I know you are there. And I know we are all going through a pretty intense time in our practices right now. But it's nice to see you all. So good morning. Thank you for joining me this morning. I am Silna Steyn. I'm the Managing Director of SSLR Incorporated. SSLR is a firm that's been specializing in evictions for 12 years now. So I've seen an eviction or two in my life. Usually when I attend a seminar or webinar presented by another attorney, I want to know what they've been doing and have you actually drafted an eviction application, because then I can understand what you are talking about. So I've been in practice for quite some time, specifically in this field. As the managing director, you can imagine that I'm not really in court ever, except in extreme emergencies or fun things like when I admit a candidate attorney, but that's about it. So I don't personally go to court, but I do have a lot of attorneys in the firm that does that, but I do see the problems, and I think the problems are pretty much what you guys want to hear about. So what I want to do is between today and tomorrow, normally when I do the eviction seminar, it's a relatively easy thing and it's the same thing year in, year out. And then luckily, just as I got bored with this, I'm lying, Barbara, I didn't actually get bored ever, but let's pretend I did. So in the days when I did the same thing over and over, and just when I thought like, I can't tell anybody anything new about evictions, thank goodness COVID happened. So at least now that's something new that's entertaining us now. So COVID obviously changed rentals and evictions and the way we are doing this completely. And I think I want to spend quite a bit of time on that. I want to talk about the actual things that we are seeing. For me to sit here today and give you all the normal theory of how an eviction should normally work isn't going to help you at all. What you are currently faced with is numerous calls from landlords, from tenants, from everybody, trying to figure out how they should navigate through this whole COVID crisis. What do we do with a tenant that can't pay rent? What do we do with a court that says, no, I'm sorry, we're not doing evictions? And you're saying, excuse me, like everybody's supposed to be doing evictions. Why is this court stuck? Or a sheriff that doesn't want to execute on an eviction order, things like that. So I want to make it extremely practical. I actually see a few familiar people that definitely attended some of my seminars in the past. And if you have attended the seminar in the past, I think you're going to see today is going to be a very different thing. If you've never been to one of my seminars, don't stress. Usually I'm on a stage and like I can actually see you and interact with you. But I do prefer to keep a webinar or seminar extremely practical, because it's not going to help you at all if you can't use what we are talking about today. Just want to ask again, guys, please mute your mics. Otherwise, I have to take half my day to just click mute all. So if you can just keep your mics muted, that'd be brilliant. So how I'm going to break it up is I'm only going to focus on residential evictions. I will tomorrow quickly touch on commercial. Not really going to be that different. But when it comes to evictions, I'm sorry, and I just Alrighty, sorry, that was just the Law Society checking if I'm alive. I am. I'm like a. So what we're going to do today is we're going to deal with, our focus will be on rentals specifically. So lease agreements, how COVID affected this, what our lease agreements are looking like. We're going to talk about all those questions that we are currently getting, force majeure, vis major, causa fortuitis, all those things. How do we respond to that? What is the answer, whether you're acting on behalf of a tenant or on behalf of a landlord? We're going to deal with all of those things. So that's going to happen today. I never want to mix evictions and rentals up, as much as they have a lot to do with each other. Right now, the biggest focus that we have is to get our non-paying tenants in illegal occupation in the correct way, so we can commence with eviction if it becomes necessary. And there are so many things that's suddenly different to the normal way. It was easy. Remember in February when life was still simple and we could send a letter of demand, a terms letter, we can place somebody on terms and cancel the agreement. That's not really as simple anymore because life is a little different. So we're going to spend time on that today. Lease agreements, rentals, and I will address commercial, retail, industrial, as well as residential. And we're going to go into the Rental Housing Act. We're going to go into the unfair regulations of the Rental Housing Act. I've sent that to the Law Society to pass it on to you guys. So it's up to you whether you want to just keep it on your screen. So you can go into that to make notes, but I'll obviously share my screen when we get to that, so you will see it on my screen as well. Alrighty, so are you ready? And then tomorrow we're going to do evictions. So my suggestion is I am going to give you homework tonight. The homework will be for you to have a read through the material on evictions tomorrow, to prepare a little, look at the flow chart, look at the way that I recommend we do evictions, and prepare for that. So when we get into tomorrow, you're already quite comfortable with what we are doing. Alrighty, so let's get going. Please don't just turn off your camera and put your mic on mute and then go do 5 other things. I tend to talk quite quickly and I move through work quite fast. So if you get up and leave for a second, there's a very good chance you're going to miss quite a bit. We will take a break at 11:30, just a quick powder your nose break. There's obviously no snacks. You're going to have to make your own coffee. Sorry, Yella, but you can get up quickly. So don't stress. We will break at 11:30 for about 5 minutes, just so everybody can, do whatever they have to. And the good news is, ladies, for today's seminar, there's going to be absolutely no queues in the bathroom because you're in your house or home or in your office. So, alrighty. So let's get going. So sorry, there we go. All right. All right. So when we talk about evictions and where we are and where we are going with this, I'm so sorry, guys. Just bear with me for 1 second. I'm just going to irritate you quickly. All right, guys. So now I can't see you, so you are more than welcome to turn your camera off. It's going to obviously save you some data there and bandwidth and the whole thing. Please keep your mics muted. And yep, that is it. So let's get straight into it. If we look at COVID and the effect it had on the property industry, just the property industry. The thing that we need to appreciate is that it's a very, very real impact on the entire economy. I mean, we can see that. We can see the president getting extremely nervous about the economy, and everybody in the country getting extremely nervous about the economy for very good reason. And the truth is, whether you it doesn't really matter in which camp you fall. If you are in the, oh my goodness, COVID is nothing more than a flu camp, or if you're in the, oh my greatness, thank goodness our government is taking extreme action to protect everybody. If you're in that camp, doesn't really matter, because for us as attorneys, we will always be seen as the people that understands the law and understands these things. It was the weirdest thing for me in full lockdown to see how the country and the world basically looked up to attorneys to try and, I'm going to broaden that and just say lawyers, to look to lawyers to try and figure out what's happening. I think during full lockdown level 5, as well as for, I think I haven't been doing articles and haven't been on the TV and on radio as much as I was during that time, because everybody just wanted answers. The funny thing is, I think you know as well as I do, it's not like we really had the answers, but we had to sort of figure it out, and at least we understand the law of interpretation and things around that. So to read and interpret the lockdown regulations, I do believe was a little easier for us than it was for the rest of the population. But at the same time, it's not like we really know any better. We can read the regulations, but the truth is we can't change anything about it. And I think that's a very good starting point. All we can do currently is work with the current regulations that we have to try and interpret that, and to try and do something different or outside of that is just not going to work. I know it's frustrating, and I do appreciate that evictions are taking much longer than it usually did, where at this stage we can't even tell our clients properly how long it's going to take and what the normal effect is going to be when it comes to rentals and evictions, because it's ever changing. And I think for us as lawyers, it's important to appreciate, as much as we normally like to know the answers, and we know we can give our clients proper timelines on how long things will take, it's just not the same anymore. We don't know, and every court is applying the rules differently. And at the same time, courts and the deeds office will close every now and again. Once again, it's irrelevant whether you agree with that or not. It's simply the way it is. Personally, I would not want to send my messengers, attorneys, candidate attorneys to a court where somebody was infected with COVID, because then that will automatically mean within a week or so from there, I'm going to have to close my firm. Now, I don't know about you guys, but the full lockdown time when our firms were closed was definitely not the more pleasant times in my life. So we want to keep our staff safe, and we want to keep our doors open. So it's going to happen that randomly we're going to have to close, that courts are going to close. And what will happen automatically is matters will have to be removed from the roll on the days that the courts are closed. Life is very different. And I must say, I think this is one of the most challenging Law Society seminars that I've ever presented. I've been doing this for the past 10 years. And I still remember the first year when I did the Law Society eviction seminar. I was much younger. And I remember I was extremely nervous, because I thought, oh, my goodness, to present something like this to attorneys, and they're going to have to use this in their practices. Do I really know what I'm talking about? And I must say, after 10 years doing this webinar, I feel exactly the same. And the truth is, at least now I can admit that, guys, currently I know in every court, the processes are different. Things are very different. So it's the first time in 10 years where I can boldly say, once again, I have no idea what I'm doing, but I'm going to wing it with you, and we're going to figure it out as we go along. So my idea for today and tomorrow is to give you guys the normal full principles, and then we will talk about how we apply this And with the different things that's going to happen and the potential things that could happen, what would that look like? So starting point, just COVID facing now. Rental collections, what is the position? So very interesting situation is there has been, we know in full lockdown, there's been a lot of fake news. There was this letter from supposedly the Minister of Health that said nobody is allowed to collect rental. Now, I don't know about you, but as a lawyer, when I saw that and I saw it's the Minister of Health, I was like, this can't possibly be right. The Minister of Health isn't the right minister to say people don't have to pay rent. If it was the Minister of Human Settlements, I think there would have been a bit more belief from my side. But unfortunately, with that happening, there's also a movement. They call themselves Rent Strike. They have a Facebook page and the whole thing. They are suggesting to tenants that they don't have to pay rent, that because of lockdown, they won't be able to be evicted, and so they don't have to pay their rent. None of those things are true. I don't even think I need to tell you guys that it's not true, because it's obviously not true. But it's very important to be aware of that. The way you're going to answer to your client when you get those questions, be it a landlord or a tenant, is there is nothing in the regulations, not since the actual initial declaration of the national state of disaster, that somebody doesn't have to pay rent. Rent is due and payable completely. This next thing is then talking about the evictions. So if we look at lockdown level 4 regulations, already in regulation 19, if I call correctly, on no, I'm lying. It was regulation 26. I still thought it's quite ironic. So in terms of those regulations for lockdown level 4, the regulations did allow for evictions, but said that execution of evictions must be stayed. Where under lockdown level 3, it's in regulation 36, which specifically says evictions may be instituted, court orders may be granted, but now they've changed the word must be stayed to may be stayed. So evictions may be stayed. Execution of the evictions may be stayed if the court feels that is in just and equitable for that particular tenant, considering his personal circumstances. And so the truth is, we're still carrying on with evictions. We're getting eviction orders daily. We're issuing new process. What I want to tell you is what we are currently seeing in practice. So just to put you in the picture, our office is in Johannesburg. So when I talk about our practice, I mostly talk about South Gauteng, North Gauteng, so Pretoria, Johannesburg, and then the Major Court in these areas. And then we have a very strong presence in Cape Town as well. So when I talk about our experience, I am talking about Gauteng courts and the courts in the Western Cape, also doing a lot of evictions in Durban. And there I must say, usually it's a bit of a slower process, and now even more so. So I just wanted to tell you, when we talk about evictions in other parts of the country, I might not have first-hand experience currently on those kind of evictions, because we are more focused on Gauteng and the Western Cape at this stage. So what we are seeing with a lot of the evictions at this stage is you get to court and you're trying to institute eviction proceedings, try to issue a notice of motion, and suddenly you get stuck with a clerk of the court that says, I do not want to issue new proceedings because it's an eviction. Now, the truth is, the clerks doesn't have the right to limit that. So what I suggest when you're in a situation like that, shame the chief magistrates, the JPs of all the courts, shame, all of them have had so many complaints, so many letters. So that's not really going to help you. What I do suggest is that you do rather, there we go, that you do rather take the regulations, send the regulations with the messenger that you want to, or the candidate attorney, whatever the case is, who has to issue the process. Take the regulations with them and show the clerk that the regulations does allow it. The thing that's very confusing in terms of the lockdown regulations, Regulation 36 specifically has a heading that says prohibition of evictions. Now, I don't know about you, but that is pretty confusing because it says prohibition and then at the same time it says but you can do evictions. So it's a very interesting thing, but just make sure that you show them the content of Regulation 36 and you can proceed with your evictions. If your eviction's been on the roll during lockdown, I think we all know that, and we do appreciate that all those evictions were simply removed from the roll or automatically postponed. And that is simply what you're going to have to explain to your client. I think most clients do understand that this is currently this situation in our courts, and this is currently what's happening. But it's important for you to explain that to your clients and say our matters are removed from the roll, and very often they are still not, even now, haven't been re-enrolled. So it is a bit of a process. It is extremely frustrating, but they should issue, and you should definitely, as part of your pleadings, ask for an order to execute your eviction order. We will talk about that tomorrow when we get into the actual details of evictions, what it looks like, and how we do that. So, practicalities around cancellation. So this was definitely more a full lockdown and lockdown level 4 problem, where people weren't allowed to move residents unless they had a permit. Currently, lockdown level 3 regulations determine that you are allowed to move residents. You can do so without a permit, provided that the move is within the district area. Now, depending on where you are, if we look at, let's take a city like Joburg, for instance, your district lines are well known to us because we are practitioners in the area. We know where the district lines are. Why? Because we know which court to go to when it comes to the magisterial jurisdictional areas. Dombe, I think you hijacked my screen. Sorry. So it's very important to be aware that our clients doesn't necessarily know where the district lines sit. So it's very important to be aware that if people move, if somebody wants to move from a residential area, but they're going to move across a district line, they do need a permit. Those permits aren't really rocket science to get, but they're going to have to go to a police station or to a court. The thing is, the regulation says that they need an affidavit. So initially I was very excited and I thought, that's brilliant. At least we can help our clients to get those affidavits because we are commissioners. But unfortunately, the regulation specifically says those affidavits must be from a court or from the police station. So in Randburg Magistrate Court, specifically Roodepoort as well, there is a magistrate dedicated to do those affidavits, and you can send your clients there to do it. Please don't take a chance and try to do an affidavit on behalf of your client. It's a little risky. If somebody has to move across provincial lines, definitely they're going to need a permit. Without a doubt, if they try to move without a permit, they're going to run into problems. I do believe that the police has eased up the roadblocks and stuff, but I don't know about you. I don't want to be the one responsible for my client getting arrested somewhere because I was the one saying, no, don't stress about it. You probably won't get pulled over. Rather get those permits if somebody moves, like I said, across the district line, but definitely don't even try and go out of a city or over a provincial line without those permits. It's really important. Why is this relevant to cancellation? On cancellation of a lease agreement, and we will go all the way up to cancellation today, and I will show you that after you've sent your MORA letter, your terms letter, your letter of demand, whatever you prefer to refer it to, you're going to have to cancel the lease agreement. And on cancellation of the lease agreement, you're going to have to place the tenant in illegal occupation immediately. Or if we don't cancel, but we are talking about an illegal occupant, so somebody that's been squatting, and we need to give them notice to vacate before we commence with eviction proceedings, what do we do currently? Under level 5, level 4, it was a very difficult situation because you can cancel the lease agreement, but you can't commence your eviction proceedings where, well, you can't demand that they vacate. So if they can't vacate, if they can't move, are they really in illegal occupation? That was the question. And I thought about this last night. I was wondering if I want to talk about this to you today, because we are in level 3, but let's be fair, we can all see our numbers rising. And if the economy can sustain that, I do suspect that at some stage in the future, if the numbers keep increasing drastically, we could very well move back to level 4 at some stage if it becomes necessary. So I'm going to talk about it just for in case we move back to a situation where people aren't allowed to move. So what we did there is you can move as long as you have a permit. So what we did for our clients is when we did cancellation letters in lockdown level 4, and the truth is we are still currently doing it, as part of the cancellation letter, we refer to the lockdown regulations and we say, we know that you can move. Here is the regulation that allows you to move. You're going to need an affidavit. You're going to need to go to a court or the police station to get that. But here is a copy of the draft form for you to get that affidavit, and you are then allowed to move. So it's very important to do that. You need to make sure that whenever you contact an illegal occupant, a tenant that you are in the process of getting into illegal occupation, that you can demonstrate to the court that you've done everything in your power to make life, let's say, as simple as possible for that particular tenant or illegal occupant to vacate the premises, so you avoid any unnecessary litigation or disputes around something like that. So make sure you do that. If you are acting on behalf of the tenants, so this is, I think for everybody that's ever been in my seminar, it's very weird if I start talking about being on the other side of the game, so acting on behalf of the illegal occupant. But I think this is going to happen more and more. I've personally had a lot more inquiries from tenants that are not being treated fairly when it comes to evictions and utility disconnections and things like that. Something very important that I want to point out is Regulation 36 under the lockdown level 3 regulations specifically says that only evictions in terms of PI or ESTA may be done, definitely commercial evictions as well. But in this regulation, so it's very interesting. We all know that Section 26 of the Constitution has always said that an eviction may only be done in terms of a court order where the court took the relevant circumstances of the tenant the illegal occupant into consideration. So now the lockdown regulations puts an extra layer of emphasis on a court order. So for the landlord that is currently doing an arbitrary eviction, lockout, a utility disconnection, whatever the situation is, he's not just in contravention of the Constitution. He's not just in contravention of the Rental Housing Act. He's also, and this is very important, in contravention of the lockdown regulations. Now remember, the lockdown regulations is in terms of the National Disaster Management Act. So the type of sentences that we are currently talking about under that isn't your normal slap on the wrist for the landlord that spoliated the tenant. Currently, the landlord or the property owner that does an illegal eviction is committing a crime in terms of the National Disaster Management Act. We are talking crimes here that will take your visa away from you. So I'm no criminal law specialist, but I've seen things in my life. So I think we all appreciate that the crime that you will now commit as a landlord or an owner, doing an arbitrary eviction is much more severe than what it used to be before this. And then something that's very close to my heart, and you will see I'm going to talk about this a lot today as well as tomorrow when we get into actual evictions, is Ubuntu. So Ubuntu is a principle that's very close to my heart, and it's something I've been preaching quite actively, especially over the last few months. So whether you love me or hate me for it, it is what it is. A lot of people, and unfortunately even lawyers, aren't aware of the fact that Ubuntu is actually a well-entrenched principle in our legal system. So Ubuntu, we have reference made to Ubuntu, not just in case law, but actually in legislation as well. The Children's Act specifically refers to Ubuntu by name. But I always find it quite curious that a lot of attorneys, lawyers tell me that Ubuntu isn't a legal principle. It's just something that the court sort of considers. Well, guys, let's think about this. S versus Makwanyane, I think that's the one case that every single lawyer in this country knows. S versus Makwanyane, if a principle was like Ubuntu, was the very basis for the reason why we no longer have the death penalty, I don't know about you, but that is pretty real legal principles. The word Ubuntu has been used in multiple court cases, specifically the word being used in more than 150 reported cases at this stage. So what is Ubuntu? If we talk about Ubuntu and when it comes to evictions, it's something that either scares people or they just don't understand, so they don't want to talk about it, but it's something very important. Ubuntu is a very simple, very real human principle. So Chief Justice Pius Langa said it beautifully in S versus Makwanyane, where he basically, and I'm paraphrasing super hard now, we basically said, guys, let's just see each other as human beings. And this is why I'm bringing it into evictions and rentals, because the truth is, if a landlord and a tenant, if an owner and an illegal occupant, if all of the parties can see each other as human beings, suddenly our rentals, our evictions, everything looks very different. So when I talk about Ubuntu and evictions, the assumption is usually that I'm talking about the application of Ubuntu on behalf of the illegal occupant. And usually the assumption is that the owner of the property will have to see the illegal occupant as a human being and be a bit nicer to him when it comes to eviction. Now, the truth is, Ubuntu, I don't want to say it's a double-edged sword, because the truth is it's not a sword or a shield. It's a human principle. It's like breathing. It's part of who we are. We are a community, and we are one as people, as citizens of the world, and we need to see each other as such. And I think as life progresses, we are seeing more of that. We are seeing more kindness. We are seeing more care. If you currently look at the very active movements around Black Lives Matter, it's amazing to see how many people come together, and that, in fairness, is one of the parts of Ubuntu where we stand together, even if it's not about you and you're not going to benefit from it in any way, shape, or form, but you are there and you are seeing people as such. And Ubuntu, when you apply that on behalf of the landlord, it is a potentially extremely powerful tool that you can use. So how we would do that, and I will show you tomorrow when we do pleadings as well, but just to get your mind going into this so long. What you can do with Ubuntu is you don't necessarily even have to use Word if you don't want to use that in a letter in correspondence, but the landlord that is currently trying to accommodate his tenant by reducing rent, by giving a rental deferment agreement, by utilizing the deposit, by doing things like that, that is applying the principles of Ubuntu. But now the tenant or the illegal occupant has to come in from his side as well and appreciate that the landlord is also human. And the tenant can't simply say, I'm not going to pay rent because Vismail or force majeure or causa fortuitis or whatever the case might be. The tenant can't just say, listen, I don't want to pay rent because I don't get my full salary. But the poor landlord is saying, excuse me, I really have, I'm running this rental at a loss. If I don't get the rental income, I can't pay my levies, I can't pay my rates and taxes, I can't pay my bond. Let's meet each other halfway. Ubuntu is a principle of meeting each other halfway. And this is what we need to see right now. I've actually done a very interesting exercise. I've recently, about a month ago, had to appoint a candidate attorney, and which I must say I'm very happy about. I know at this stage there's a lot of people that are unfortunately unemployed, so I was very happy that we were in a position to have to do that. And then, I made all the candidate attorneys, I've asked all of them to write an essay on how Ubuntu will apply to an eviction. And the truth is, from about 150 essays that I received, only 2 people understood how you will apply that on behalf of a landlord. And I think that's something that I want to talk about a lot today, because if you can apply Ubuntu on behalf of your landlords, on behalf of your clients, you will definitely put them in a much stronger position. So now I'm going to give you a bit of homework on the whole Ubuntu thing and the how lockdown has affected these relationships. But unfortunately, it's not a quick thing, and I don't have too much more time to talk about that. So now I'm going to give you homework. If you go onto YouTube, SSLR, so my firm, and luckily it's not rocket science, right in front of you, SSLR. If you go onto SSLR's YouTube channel, you will see I had an interview with Advocate Viljoen Myers about Ubuntu and the application of Ubuntu on evictions. There's a lot of other episodes as well that I've done on the lockdown regulations, on the way it impacts the current situation in the property industry. So if you have time, or actually I want to ask you politely to make time tonight just to watch the Ubuntu conversation I had with Viljoen Myers. If you have a bit more time, or you are bored or whatever, you are welcome to watch a few of the other clips. It might help you a lot going into details tomorrow. So I know I just gave you homework. That is the weirdest thing. But please go have a look at that video. I really do believe it's going to help you going forward. So that's my COVID-19 update for the moment. And now I'm going to pretend like we're back in February and we're just talking about life as normal. I'm lying. I promise I won't. We can't talk about life as normal because we are currently in the new normal. So let's get into the details of the relationship between a landlord and a tenant and lease agreements. So lease agreements are the most important part of the whole relationship between a landlord and tenant. So why I'm talking about rentals and lease agreements is for us as attorneys to do the best evictions, to do the most effective evictions, we really need to understand that lease agreements, how lease agreements work, how they apply, and how we can cancel them. What are the rules of the game, and what does the Rental Housing Act say? What do we need to know? Because the truth is, more often than not, your evictions success is already going to start in the conclusion of the lease agreement. Because the problem is most landlords and tenants doesn't really even know exactly how to use the lease agreements, how to do what they have to do when there is a problem when it comes to the lease agreement. And the truth is, when we talk about residential lease agreements, almost all the answers that you ever need will be not just in the Rental Housing Act, but even more so in the regulations that form the unfair regulations that forms part of the Rental Housing Act. So I've asked the Law Society to send it out to you guys. So currently you will have the Rental Housing Act as well as the regulations in front of you. So if you don't have it, don't stress about it, but I am going to make reference to it. The thing is, the unfair regulations is actually quite simple. You will see Regulation 6 is one of my favorite regulations. The reason why that is that is the regulations that deals with the relationship, the practical relationship between a landlord and a tenant. So regulation 6.1 deals with what a landlord must be doing and must not be doing, and regulation 6.2 deals with what a tenant must and must not do. So it's very important. Please read through those. It's going to make your life as an attorney much, much easier. I can promise you all the answers are right there. But if we look at the lease agreements are crucial in the sense that it forms the very basis of the relationship between a landlord and a tenant. Residential lease agreements, much shorter every time than a commercial lease agreement. Why? Because residential lease agreements are completely legislated and completely regulated by the Rental Housing Act and fair regulations. So you can basically leave half the things out when it comes to a residential lease agreement, where a commercial lease agreement has to contain every single element of the relationship between the landlord and tenant, because it's completely unregulated. I had a client during the course of the week give me a call, well, not a client, and just an inquiry, who said he's very, very upset because he rented a commercial premises and his landlord cannot prove that the deposit was invested in an interest-bearing account. To which I said, does your lease agreement require you to, does the lease agreement require the landlord to invest the deposit in an interest-bearing account? And he said, no, but the law says he has to. And I said, unfortunately not. The law only requires that in terms of the Rental Housing Act. So the Rental Housing Act, Section 53D, Section 53D says that the deposit must be invested in an interest-bearing account. But the Rental Housing Act, guys, only refer and only deal with properties that is used as a place of residence. So there is nothing in commercial, retail and industrial properties by legislation requiring A, a deposit to be charged, B, that the deposit be handled in a specific way, and especially not that the deposit has to be invested in an interest-bearing account. This is, in fairness, why the residential property companies are making proper profit, because they can utilize the deposits to reinvest as long as they have the capital available, obviously, to refund the deposit at a later stage. This opens the conversation about deposit payment when it comes to a residential property. As part of the COVID relief, a lot of landlords asked whether they are able to utilize the deposit for payment of rental. Now, the truth is, Section 5.3 DE, now I'm like C, of the Rental Housing Act says that a landlord may request a tenant to pay a deposit. Now, the truth is, most of the times in a residential property, it's very wise to ask for a deposit, because if there's any issue on that, if there's any problem, in the sense that the landlord can't pay, the tenant can't pay, say for repairs, or he broke a window, whatever the case might be, you then have the funds available to repair that. However, the Act doesn't require the tenant to pay a deposit, and there's no obligation in the Rental Housing Act that demands that a landlord may not release that deposit. So a deposit may not just randomly be used, and most of the times lease agreements, I personally draft lease agreements like that as well, does not allow the deposit to be utilized for rent. What the parties can, however, agree to is to release the deposit in full to the tenant. Remember, it is the tenant's money. If the tenant then wants to use that for payment of rent, it's fantastic. Only problem is, and I caution my clients and everybody around this a lot, to not utilize the deposit and then think at a later stage the tenant will miraculously have money appear while he is still unemployed, especially in a situation where somebody lost his job completely because of COVID. To then utilize the deposit will simply delay the inevitable. But you are allowed to utilize the deposit for payment of rent. But please remember, when it comes to utilization of the deposit, or when it comes to reduction in rental, or for that matter, any amendment to your lease agreement, those must be in writing and signed by both parties. It's very important to appreciate that and to make sure that that is done, so the parties know exactly how to act when there is breach of those particular agreements. Where does the rental agent fit in? Because lease agreements, more often than not, is done by the rental agent. So for us as attorneys, where and how do we deal with the rental agents? The rental agent's involvement is very different, and it is simply based on the mandate agreement between the landlord and the agent. Remember, an agent, a rental agent, can never, ever, ever, ever be a party to a lease agreement. If you have a lease agreement where the rental agent is a party to the agreement, it cannot possibly be enforceable. Something very important is also that your commission and the commission that is payable towards the agent cannot be dealt with in a lease agreement. It can be made mention of, but that's not the basis of that agreement. A lease agreement can never be a tripartite agreement. There can't be a landlord, tenant, and agent. A lease agreement in its nature can only be between a landlord and a tenant. So if there are ever disputes that you are faced with and there's a rental agent involved and the dispute relates to the agent, make sure that you're not trying to base your arguments on the lease agreement, but that you base your arguments exclusively on the mandate agreement. Something important about the mandate agreement, it does not have to be in writing, and it is allowed to be verbal. However, the Estate Agency Affairs Act specifically says that if it is a sole mandate has to be in writing. So a procurement mandate for a rental agent, so the agent that has to advertise the property, find prospective tenants, do the tenant vetting, those kind of guys. That's brilliant. Those agreements doesn't have to be in writing, but the truth is, in my mind, a management agreement can be nothing other than a sole mandate, but it's not for a specific term. So even your management mandate, I think there's a lot of arguments to be made that can in fact be verbal, and very important that must actually be in a separate agreement. And if it's referred to in the lease agreement, fine, but you can't enforce those agreements from a lease agreement. It must be in a separate mandate agreement. I've seen it a lot of times, and this is why I'm bringing it up, especially from opponents when we are busy with evictions, raise issues with regards to the lease agreement and the actions of the agent. Guys, please keep in mind, the agent is not a party to these proceedings. So for all intents and purposes, if you can't ever base a defense for eviction on the actions of the agent, you need to base it on the actions of the landlord, because at the very best, the agent is acting instead and on behalf of the landlord. So please make sure you litigate against the correct parties when it comes to these things. Don't try and pull the estate agent in where the action is actually just between the landlord and the tenant. So a lease agreement must be clear on the following. The lease premises. So every time I say this, I see people look a little surprised about it. Obviously, it must be clear on the lease premises. So here's a little fun story. Especially in sectional title properties, your door number and your registered unit number are very often not the same. So if I have conveyances in the webinar, I suspect I would. Conveyances, you know exactly what I'm talking about. It happens so often. So when you consider a lease agreement, so when you consider an instruction for eviction, my advice, and it's almost not even advice, it's almost like if you don't do this, you're going to run into problems. When you open your file already, please do a deed search, guys. I have seen so many lease agreements, and really, I'm not even almost exaggerating here, where the parties or the lease premises or something like that was recorded incorrectly. The problem is, if you commence your proceedings, so your initial letters already, by using the wrong say for instance, door number or property description or description of the parties, and that is not actually the property that's going to appear on the deed search, or it's not the parties that's appearing on the deed search, you're going to run into major problems. I do appreciate that we can do rectifications in our papers, but we don't want to do that. I know that Morris in his technique in litigation said that you rise and fall by your founding affidavit. But I must say, I think that's the true words of an advocate. As an attorney, I always say you rise and fall by your correspondence. Your success in your litigation is always determined by your correspondence. Your pleadings are crucial, and your pleadings are very important. Your founding affidavit is absolutely crucial. But if you do not have the correct correspondence initiating your proceedings, you're already going to lose your matter on correspondence. I've seen so many times that attorneys jump straight in with litigation and correspondence and then record incorrect things in correspondence. The problem is you can't undo correspondence ever, and it will come up. I've seen a post on social media recently that said, dance like nobody is watching, that thing. But when you write a letter or an email, please write it in a way that you know a judge is going to read it sometime in future. So that's exactly my point. Please don't ever write a letter or address correspondence to try and get a reaction, hoping that that's not going to surface in your case later, because that's exactly what's happening. We are currently busy with an urgent application. I don't even want to tell you guys about the correspondence that my client addressed and the kinds of words that they are using in this correspondence, and already came out in answering affidavit now. And you know how embarrassing that is. We can deal with that if it's our clients, but please remember that when you send a letter on your letterhead, when that thing comes up in court at a later stage, you can't just say, oh, my lord, I'm so sorry. I actually just wanted to scare the tenant a little to move out. We don't have the right to do that. We, as attorneys, have to act 100% in line with the law, and you can't use your correspondence as a scare tactic. If you want to, go wild, but make sure you act completely within the legal boundaries, and whatever you put down on paper is actually correct in law, because it will come up in correspondence at a later stage. So why this is relevant is, if you address a quick letter and you thought, ach no man, I'll just scare this tenant out, I'm not going to have to worry, it's never going to go to litigation, you record the property address incorrectly, or you address the correspondence to the wrong party. You don't include both tenants, for instance. You only address the letter to one of the two tenants. It means that you then not corresponding with all the parties. You are not corresponding in the right way. And that is exactly the type of correspondence that will have that will potentially be fatally defective in future when you have to use that. The problem is we unfortunately can't go back in time to fix correspondence, because once you hit the send button on your email, that letter is out and it can't really be undone. You can always withdraw correspondence in further correspondence, guys, but it's embarrassing. If you send like a super over the top aggro letter to later send a further letter saying, hello, Yella, so sorry about that letter. Please ignore that. It just looks silly, and that will be in front of court as well. So please make sure your correspondence from the very start is 100% correct. Your lease agreement must be clear on that the lessor leases to the lessee and the lessee hires from the lessor. That's obvious. Then your rental payments and the terms of and the term of the agreement, not the terms, the term. Rental payments, crucial. Why I'm mentioning this here is, remember, rental payments isn't always money. There's very often a different arrangement between the landlord and the tenant. For instance, if we talk about farmland, I spoke to a colleague during last week who had a lease agreement between farmers where the farmer is paying in a form of grains, and there's like this whole thing about the quality of the grain that he has to deliver. Please make sure that the rental payments is described in full detail, especially if it's not money. But when it is money, deal with it proper. Don't make it an amount that has to be calculated. Make sure that the amount is clear. Tenant knows what he has to pay, because the last thing you want is to have a dispute about the terms of the lease agreement. Why am I so on about the lease agreement? If you have a dispute around the terms of the lease agreement, you suddenly open the door for a trial instead, for action proceedings instead of motion proceedings. And you will see as we go through today and tomorrow, the one thing that I'm very, very big on when it comes to evictions is we need to do this on motion, on application. The moment we go to action proceedings, it is a long, drawn-out process. So what you want to do is, before you commence with anything, you want to make sure that lease agreement is clear on everything. And if you pick something up in the lease agreement that is potentially, that's going to potentially cause a dispute, try to sort that out prior to litigation on correspondence, so the parties can be clear around that. Because if you have to clarify these things under oath, it's going to be a 2-year eviction, and that's the last thing we want. Then the term of the agreement, very important. Quickly on term of the agreement. We're obviously going to talk about the Consumer Protection Act still. And the Consumer Protection Act specifically says that a fixed term agreement may not exceed a period of 24 months unless the supplier, being the landlord, can demonstrate a financial benefit to the consumer. So the consumer, obviously here being the tenant. Guys, it's not rocket science to prove financial benefit to a tenant for a lease agreement that exceeds a period of 24 months. Reason why I'm saying that is obviously that he doesn't have to pay a deposit somewhere else. He doesn't have to move. So even if the lease agreement doesn't capture that financial benefit, the supplier can easily demonstrate financial benefit to the consumer, and a lease agreement, even governed by Section 14 of the CPA, can definitely exceed a period of 24 months. Also, please remember, if you're acting on the other side, you can't ever utilize a lease agreement that exceeds a period of 24 months in a way to invalidate the contract in any way. Even if it's not just a lease agreement, it simply says that it's not in line with Section 14 of the CPA, doesn't automatically invalidate the particular contract. But in lease agreements, it's never a problem. It can always exceed a period of 24 months. And so these are the essentialia of a lease agreement. An undertaking by the landlord to give the tenant the use and enjoyment of the property. Agreement between the landlord and the tenant that the tenant's use and enjoyment of the property is temporary. So guys, this is crucial. Temporary, this is part of the essentialia, right? So the moment you have an unlimited lease agreement, so it creates more a life right, then it's not an invalid contract, it's just no longer a lease agreement. So make sure you're aware of this. And if you work on a contract that isn't temporary, it's something else, just make sure you don't plead that it is a lease agreement. Plead whatever it is. You can just say it is an agreement. But the moment you plead that something is a lease agreement, go back to this slide every single time and make sure that you comply with the essentialia of a lease agreement when you get around to that. An undertaking by the tenant to pay rent in return for use and enjoyment of the property. So this is the only essentialia we have in a lease agreement. If you do not have these terms and reference to these terms in an agreement, that agreement can be a valid agreement, but it's just not going to be a lease agreement. So let's look at bridge. So now I'm taking you all the way back to law of contract, which is my personal favorite subject. But this is the types of bridge that we get. So positive malperformance. In a lease agreement, you're not easily going to run into this, but it could happen now suddenly, thanks to, again, COVID situations. So a tenant that is paying bad, is not paying his full rent, will still be more mura creditoris than positive malperformance. A landlord, however, can fall in this category much easier. For instance, he has to provide, he has to do the necessary maintenance to the premises. So say, for instance, the parties agree to something he doesn't perform in terms of that. This could be a thing, but positive malperformance isn't a type of bridge that we deal with in rentals very often. Mura debitoris neither, but mura creditoris majority of the times. A tenant that's not paying rent. Repudiation, oh my goodness, guys, I'm going to scare you on repudiation when we get to the cancellation of lease agreements. Unfortunately, repudiation, very often when it comes to lease agreement, the party repudiating is the landlord, unfortunately, with the attorney on his behalf repudiating unknowingly. But I will talk about that when we come to cancellation. And then prevention of performance doesn't really happen that much. So remember, these are the only forms of bridge in terms of the law of contract. And then, thank goodness, we have specific remedies to these types of bridge. Why I'm talking about this is when we come to placing a tenant on terms, cancelling the lease agreement, it's very important that we identify the type of bridge very clearly, and you need to know that it does fall within one of the 5 categories of bridge that we have, and that you then only elect one of the available remedies. So the remedies that we have available when it comes to the law of contract is to obviously acceptio non adem pleti contractus, where the innocent party withholds performance until the other party performs. This is a pretty handy one. I've seen a lot of people assuming that you can apply this remedy without notice. And what it looks like in rentals specifically is the tenant that says the landlord is not performing the necessary maintenance, so he is going to withhold his rent until the landlord performs the maintenance. So something very important here, everyone. This is a normal remedy like cancellation, like specific performance, like a claim for damages or a claim for penalties. Exactly the same thing. You can't just jump this onto the other party. It's not something that just falls out of the sky and you say, hi, so by the way, I'm cancelling the agreement because you've been in breach of the agreement. That's not how it works. We're attorneys, and I think we appreciate this a little bit more, that the correct way of getting to and applying a remedy to a breach in law of contract means that you have to place the defaulting party in mora before you can implement and act on any one of your remedies. Now, how we do that will have to be by sending a letter, and all of this has to happen in terms of the lease agreement or by way of law. So if we look at the Consumer Protection Act, Consumer Protection Act is pretty clear on the time periods that we need to give. So is the Rental Housing Act. But if these acts doesn't apply, you're only going to fall back on the lease agreement and the lease agreement will tell you what the time period is you need to give to the defaulting party to remedy his breach, and if he doesn't remedy his breach, you can then act on the remedy. Very important, you have to elect your remedy already when you send your MORA letter. So when you place the defaulting party on terms, you have to already say which remedy you're going to elect. Now, I've seen so many letters, unfortunately, from colleagues, which says that you are in breach of this or that provision of the agreement, and we reserve our client's right to cancel the agreement, claim specific performance, or claim damages. Now, the truth is that is not complying with the provisions of the law of contract, with the regulations of the law of contract. You have to pick your remedy in advance. You can't leave it open and sort of hope for the best and then decide which gun you're going to use when you get there. You have to pick. Remember, sometimes you can use these in combination. For instance, you can go for cancellation and a claim for damages. But you can't go for cancellation and specific performance. It's mutually exclusive. And so you have to pick your remedy in advance. Cancellation is a very obvious remedy. You cancel the agreement, and all the terms of the agreement is cancelled when you cancel the agreement, so no performance is further required. But you will have a damages claim for the portions that the parties are not performing in terms of because of cancellation of the agreement. Then we have specific performance. Specific performance, obviously, extremely limited jurisdiction. Only the High Court has jurisdiction for specific performance, with a few exceptions. A specific performance in terms of a lease agreement does not form part of the exceptions. So you will have to go for specific performance in the High Court. My problem with specific performance when it comes to your typical lease agreement is it's pretty nonsensical, with all respect to anybody that's ever done this, unless there's a very good reason. For instance, the parties agreed that the tenant will rent this particular property. They've done specific tenant installation. It is a 9-year lease agreement, and it is in a place where the landlord won't really find another tenant. In those circumstances, where it's a longer term thing, I would definitely go for specific performance, but I will add in a prayer to ensure that I don't have to return every single month when my tenant is in breach. But in most instances, stay away from specific performance when you're acting on behalf of the landlord. However, where you're acting on behalf of the tenant and the landlord is causing some or the other form of shenanigans, for instance, the landlord's not doing maintenance, the landlord keeps on rocking up to the tenant's premises unannounced to do inspections, and I say that in inverted commas, where he's not giving the tenant undisturbed use and enjoyment of the premises. In those circumstances, I will definitely place the landlord on terms and then tell him that I'm going to claim specific performance instead of cancellation, because your tenant doesn't want to necessarily cancel and vacate the premises. He just wants the landlord to perform in terms of his obligations. In those situations, if it makes financial sense, specific performance is definitely a very good option. Damages claim makes sense. Penalties doesn't really make sense in terms of rental. This is more for building contracts, things like that, that has a specific time period attached to it. So let's talk about the Rental Housing Act. And I gave you guys so much homework. I don't think you're going to have much time tonight for anything else. So, you know, at least you can use it as an excuse to not cook. Tell yourself you can get McDonald's tonight to support the economy because you have too much homework. Rental Housing Act, guys, please have a read through it. It's really an important act for us to understand. Section 5, especially most important section dealing with the practical things around rentals, what a lease agreement must and must not have. So the Rental Housing Amendment Act was published on the 15th of November 2015. So but I'm also not good with mathematics. I'm also an attorney, but that's almost 5 years. So very important here. That act has still not been promulgated. I cannot imagine that it will be promulgated in its current form. The reason why I'm saying that is If an act has been lying published but unpromulgated for a period of 5 years, I do suspect that Parliament has a few issues with the particular act. Otherwise, he would have been promulgated by now. Please don't advise your clients in terms of that act. It's irrelevant. It's almost like referring to the amendment to the Prevention of Illegal Evictions Act that was published in 2005. So all of us know that that amendment to PI hasn't been promulgated. I don't think there's any plan to promulgate him anytime. Similar with the Rental Housing Act. Please work on the current act that we have. The Rental Housing Amendment Act is 100% irrelevant to our lives at this stage. If he suddenly gets promulgated in its current form, I will smile politely and say I was wrong, but we will know about it. Currently not yet amendment. So one of the big things about the Rental Housing Act doesn't require lease agreements to be in writing. Rental Housing Amendment Act does, but since he's not promulgated, it's pretty much irrelevant to our lives. Lease agreements doesn't have to be in writing. But at the same time, I think it's completely silly to have a lease agreement that is not in writing simply because it's almost impossible to prove the terms of the agreement, especially by the time that the parties are in some or the other dispute around that. Obviously, the parties will say, will then disagree on the terms of the agreement. So make sure your lease agreement is in writing. On this topic, I will mention that I do recommend to my clients and to most attorneys as well, to have a look at the TPN leaseback lease. It is the widest used lease agreement in South Africa currently. I personally draft that lease agreement and I've been doing so since 2014. The reason why I'm promoting that lease agreement is not because I drafted it and I just want people to use my lease agreement, not at all. Reason why I'm suggesting that is judges and magistrates are getting pretty comfortable with that lease agreement. So as legal practitioners, we all appreciate that if you are basing your action or your motion on a written contract, you have to attach the contract. And we all just hope that the magistrate or the judge has enough time to read the full agreement. But let's be fair, nobody has that kind of time. Even residential lease agreements, you don't really get away with anything less than 15 pages. There's no way that a judge or magistrate with 15 matters on the roll, and that's on a good slow day, are able to read the full agreement. So because they are more comfortable with the leaseback, majority of the national agencies are using the leaseback as the basis of their agreements. More and more people are getting comfortable with the content. And that also means that landlords and tenants know exactly what the agreement is on about. And it's really important because it makes it easier for all the parties to understand their personal obligations. So the Rental Housing Act brings in a beautiful balance of rights. We get the questions, and I believe you will too. The question is always simply from property owners or landlords. They will make a statement first. They will say, landlords doesn't have any rights. The law favors the tenant or the illegal occupant. How do we respond to that? Well, the truth is, the right of ownership is an extremely strong right. The right of ownership isn't one right. The right of ownership is a bouquet of rights. Why I'm using the example bouquet is, as much as it's one thing, it's made up of a lot of different things. So as part of the right of occupation, you have the right to sell the property. You have the right to use the property as security for a loan. You have the right to destroy the property, obviously within certain limitations. If you're in the middle floor of a complex, please don't destroy the property. But within bounds, you are allowed to handle the property as you deem fit. But one of the rights is the right of occupation. Now, the right of ownership isn't a separate right from the right of occupation. The right of occupation forms part of the right of ownership, which by definition means that the right of ownership is an overpowering right that the that the owner has in comparison to the occupant's right of occupation. So Section 25 of the Constitution deals with the right of ownership. It's a real right, one of the strongest rights in our law. But then immediately in Section 26 of the Constitution deals with the right of occupation. And I think it's beautifully drafted, because we say we will protect your right of ownership. It's a very strong real right, but it's an overpowering right in comparison to the right of occupation. Section 26 of the Constitution reads, no person may be evicted or have their property demolished and without a court ordering to do so after the relevant circumstances has been taken into consideration. So the Prevention of Illegal Evictions Act, the Rental Housing Act, all these acts are there to support Section 26 of the Constitution. It's in line with the Constitution, obviously, and it is very important to be aware of this fact. If these acts weren't there, and I'm talking about the Rental Housing Act and Section 26 of the Constitution, if these provisions wasn't there, the right of ownership will outweigh the right of occupation in such a way that we will kill our rental market in South Africa, because the rights of the owner will just be too strong for the tenant to comfortably go about his way and using his right and using the premises to have the full use and enjoyment of the premises. So it's there to bring a balance of rights, and it's really, really important that we have that. The Rental Housing Act deals with lease agreements, how they should be drafted, and luckily on your homework you're going to read those acts. And if you have any questions in that regard, we can definitely talk about it tomorrow. Then, like I said, the effect of the amendment bill is irrelevant because we're not going to apply that. But unfortunately, a lot of our clients did read articles or something around that was published prior to promulgation of the Act. And I mean, the Act still hasn't been promulgated. So if you get questions around that, at least you know how to respond to that. So before I get into the Consumer Protection Act, I just want to touch on it quickly. I think let's take a quick break. I promised we're going to take a break at 12:30. Now it is 11:27, so I'm a little ahead of time here, but let's do this. Let's take a 5-minute break. Like I said, at least you don't have to go stand in queues in bathrooms, but let's take a quick break, and I will start again at exactly 5 minutes past 11. So I unfortunately can't check if everybody is back on their seats, but I'm going to have to start at not 5 minutes past 11. That's in the past, at 11:35. So you have exactly 7 minutes to make coffee or tea or do whatever you have to. And I'll start at 11:35 again.
I'm oh, okay.
All right, so I hope everybody is back. I must say it was the weirdest thing to take a break and nobody is running to me to ask questions. It was very strange, but I promise I'll give you time just now for questions. So I just want to deal with the Consumer Protection Act so we get our head in the right space. So going through cancellation to get to the point where we can commence evictions is very important. So the Consumer Protection Act, been around since the 1st of April 2011. I think at the time we thought it's quite ironic that it was promulgated on the 1st of April. Turns out after, almost 10 years, we can clearly say that it wasn't an April Fool's joke. It's actually a pretty real piece of legislation. The reason why this could be relevant is Section 14 of the Consumer Protection Act deals with fixed term agreements. So whether to determine whether the CPA, specifically Section 14, pertains, will govern a lease agreement or not, is simply based on the nature of the contract and then the parties involved. So the first question you need to ask yourself is this lease agreement in front of me a fixed term lease agreement? So is it a 6-month agreement, a 2-year agreement? And like I said, even a 5-year agreement, provided that the parties can demonstrate financial benefit then to the tenant. So if it's not a fixed term agreement, if the agreement is a month-to-month agreement or something like that, it cannot ever be governed by Section 14 of the CPA. So you don't even have to think about it any further. You don't have to consider the annual turnover or asset value or anything. Guys, I'm sorry, I'm just going to interrupt myself. Somebody is not on mute. And since I am no longer the host for the moment, I can't mute everybody. So don't you please want to do me a favor and mute your mics. Tombi, or if you can maybe just mute everybody for me. You are currently in control of the webinar. And Tombi, if you can just mute everybody, that'd be brilliant because I'm having a bit of intense feedback in my ears. Alrighty. So if it is a fixed term agreement, you need to go to the next question. And the next question is, who are the parties? Section 14 of the CPA says that this section will apply to all fixed term agreements unless it's entered into between juristic entities, regardless of their asset value and annual turnover. So very important, guys. Asset value and annual turnover is completely irrelevant when it comes to application of Section 14 of the Consumer Protection Act. Only time where it will become relevant is if there are any of the other provisions of the CPA that could be relevant, then asset value and annual turnover will be relevant. But as far as it pertains to Section 14, it's really not. Guys, I am really sorry. I have a lot of feedback. Somebody's mic is not on mute and I can't even almost see you. And I can't do anything about it. So either, Tombi, will you please mute everybody for me? Or if you are listening to me, please make sure your mic is on mute because I can't think when I can't hear. So if the agreement is entered into between two juristic persons, then Section 14 will not apply. If one of the parties, and I'm specifically saying either one of the parties, is a natural person, Section 14 will apply, even if that party is the landlord. I know it feels counterintuitive, but it's the way the Act was drafted. So even if your landlord is a natural person and your tenant is a juristic entity, very important to be aware that Section 14 will still apply. Even more importantly here is if you have Section 14 of the CPA apply to your lease agreement, you need to make sure that you do everything in your power to comply with all the provisions of the CPA. The reason why this is important is you're not going to argue your way around legislation. You're not going to try and explain to court that you decided not to give the tenant 20 business days to remedy his breach because you have a different provision in your lease agreement. Guys, you cannot contract out of legislation ever. So when Section 14 of the CPA applies, so when it's a fixed term agreement and at least one of the parties is a natural person, you need to give the tenant 20 business days, or for that matter, no, it's irrelevant to the landlord. You need to give the tenant 20 business days to remedy his breach. Only if he doesn't remedy his breach will you be able to cancel the lease agreement. You can't give the tenant notice in your letter and say the letter will, the lease agreement will automatically be cancelled after 20 business days. You can't give the tenant 7 days and then give him 20 days to vacate. You can't do funny things like that. The Act says 20 clear business days for the tenant to remedy his breach. Only if he doesn't can you cancel the agreement. The good news about the cancellation is then obviously on cancellation it renders the tenant's occupation illegal and you can commence with eviction proceedings immediately. Very important, juristic entities in terms of the Consumer Protection Act is defined as much wider than just a normal juristic entities being a company or a closed corporation. It's wider. It also includes trusts, partnerships, associations, and body corporates, and yeah, that's it. Trust, associations, partnerships, and body corporates. Very important to be aware of that. So remember, if the lease agreement is between two juristic entities, then Section 14 will no longer apply. So just make sure you know who the juristic entities are in terms of the Consumer Protection Act. The tenant has a right to cancel the lease agreement during the subsistence of the lease by giving the landlord 20 business days notice of the said cancellation. Remember, your cancellation is not effective on the day of notice. Your cancellation is effective on the day of cancellation, so the last day of that notice period. Landlord is entitled to a reasonable cancellation penalty. However, that is no different from the actual damages that the landlord is suffering. However, if the lease agreement says, for instance, the reasonable cancellation penalty will be a fixed amount of 5,000 Rand, for argument's sake. If the landlord's damages exceeds 5,000 Rand, the landlord will not be entitled to claim anything more than the agreed to penalty in terms of the lease agreement. That is very important to be aware of. It's really crucial that you look at this. Please never jump into a claim for reasonable cancellation penalties, whether you act on behalf of the landlord or the tenant, without really having consideration of the lease agreement. If the lease agreement is silent, however, on a penalty, the landlord doesn't lose his right to claim the damages that he suffered in terms of the early cancellation. Landlord will always have an obligation to mitigate these damages as far as possible. And what this will look like is the landlord will be required to market the property as soon as he receives notice of the cancellation. And he should potentially, if you look at a situation like right now, again, I'm back to the COVID thing. If you look at something like that right now, it's very important to be aware of the fact that the landlord might even be required to reduce his rent a little bit because the rental market is definitely taking quite a lot of knocks right now. So rent definitely dropped. Rental over the past 3 months is definitely lower than it was, let's say, in about February. So very important. The landlord can't say that he did his best to mitigate his damages, but he's refusing to adjust his rent to a position that brings it back in line with the market value. Will he then have a damages claim for the loss of income because the previous tenant cancelled early? Well, very likely, yes. Once again, depending on the content of the lease agreement. Then, like I said, landlord can cancel the agreement if the tenant is in breach. He gave the notice, written notice, 20 business days, and the tenant didn't remedy that breach. very important when it comes to residential properties. In terms of the Rental Housing Act, Section 45C of the Rental Housing Act, a landlord will be entitled to cancel a lease agreement mid-term on 2 occasions. This will be in a situation where the landlord made provision for such cancellation in the lease agreement, and if the landlord does the cancellation based on something that does not constitute an unfair practice. So what I'm saying is, if the lease agreement says the landlord is allowed to cancel the residential lease agreement during the subsistence of the lease agreement for specific reasons, and reasons that will not constitute unfair practices would, for instance, be if the landlord wants to take occupation of his premises, if he wants to sell the premises, things like that does not constitute unfair practices. The things that will constitute unfair practices is the landlord that wants to cancel the lease agreement because he can get a higher rental income from another tenant. If he wants to cancel the lease agreement because he just doesn't like this tenant, those are unfair practices and those cancellations aren't valid. Question that I always get is, but isn't this in contrast to the principle of huur gaat verkoop? It really isn't. Remember, the principle of huur gaat verkoop says the provisions of the lease agreement that is currently in place will be sold with the property. The tenant goes with the property, and on registration, the purchaser will simply step into the shoes of the landlord. Simple as that. The fact that the landlord has the right, in terms of Section 45C of the Rental Housing Act, to cancel the lease agreement midterm for specific reasons, simply goes onto the purchaser. So if the landlord wants to cancel because he wants to sell the property, he is well within his rights to do so, provided that the lease agreement provides for this. Very important. So have a read through Section 45C, get comfortable with that, and obviously if you struggle with that, make sure you make a note of that, and we can discuss that in tomorrow's session. Or now, you're more than welcome if we talk about in the question and answer section. All right, so I want to get to cancellation of the lease agreement. I'm so sorry, I'm popping through my slides here. So I want to talk about cancellation of the lease agreement. Something very important. I just want to make sure my slides look confusing me extremely here this morning, but don't stress about it. So it's something very important. When we cancel a lease agreement, it has to be done in a very specific way. And this is the last thing I'm going to address today. Well, so if you're tired of my voice, don't stress. I'm going to only take another about 10 minutes on explaining this, and then we will go over to a question and answer session and a few discussions potentially. So if we cancel a lease agreement, now I'm opening the door completely on every type of lease agreement. Commercial, retail, industrial, residential, any lease agreement. Like I said earlier, if a tenant is in breach of the lease agreement, or for that matter, a landlord, but let's focus on the tenant that is in breach for the time being. If a tenant is in breach of a lease agreement, you need to send him a notice and give him a certain time period to remedy his breach. So very important, the certain time period, if the CPA applies to this agreement, as I said, fixed term agreement, and one of the parties is a natural person, then you need to give the tenant 20 full business days to remedy the breach. Only if he doesn't remedy his breach will you be in a position to cancel that lease agreement. This must be a separate notice. Your cancellation and your letter of demand, Mura letter, terms letter, whatever you prefer to call it, must be separate notices. If the lease agreement is not governed by Section 14 of the CPA, the time period you're going to give that tenant to remedy his breach will simply be the time period reflected in the lease agreement. If the lease agreement is silent on this, I would err to safety side and give them 7 days. A lot of commercial lease agreements allow for immediate cancellation. And if the CPA, Section 14 of the CPA does not apply to that lease agreement, 100% valid, you are allowed to cancel the agreement with immediate effect. However, most lease agreements will have to have a certain time period attached to it. It will be in the lease agreement. If the lease agreement pertains to a residential lease agreement, and the lease agreement is silent on the time period that you need to give to the tenant to remedy his breach, you can give the tenant, you must give the tenant 7 calendar days. This is in terms of the Rental Housing Act to remedy his breach. On a commercial lease, you can suck if the lease agreement is silent on that, give a time period that is reasonable. Residential, that's silent, give him 7 business days. Lease agreement, anyone, commercial or residential lease agreement, that says that you can give the tenant anything less than 20 business days, but you know that the Consumer Protection Act applies to that agreement. Legislation will always override the provisions of a lease agreement, and you still need to give the tenant the full 20 business days notice. So very important here. If you do not give the correct time period for the tenant to remedy his breach, or you do not deal with a potential dispute or issue that the tenant raises based on the notice that you gave them, and you just proceed and cancel the lease agreement. This is a very scary part of the story, because you then effectively repudiating the terms of the agreement. Remember, repudiation is defined as a clear communication that the parties will no longer be bound by the terms of the agreement. Now, cancellation that is done correctly, placing somebody on terms, allowing time to remedy his breach, that cancellation is 100% effective and allowed, and there's no issues when it comes to that. Very important to be aware of this. The problem that you're going to have when you cancel the lease agreement without giving the correct notice or doing a premature cancellation, whatever the situation might be, that is repudiation, because what you are saying to the tenant is, I will no longer be bound by the terms of this agreement, and you do not even have a reason to do that. So this is crucial. Be very careful of that. I'm going to tell you a fun story about that, just so it really sinks in. At some stage in my life, I had quite a lot of I did a lot of letters of demand and stuff myself. It was a while back. So for one of my favorite and biggest clients, Grove Point, I got an instruction on a Friday afternoon. So it was one of those Friday afternoons where I saw, shame, my secretary isn't really there. She's not really feeling it anymore. The week is over, her handbag's already packed. So I got the instruction. And because I've been working on this particular client's matters for such a long time, I was pretty much used to the way the lease agreements are drafted. And this is a very scary story. And I thought, you know what, I'm not going to ask my secretary to do the letter of cancellation. I'm going to do the cancellation myself. The problem was, I am used to Grove Point's lease agreements allowing for immediate cancellation on the day of non-payment of the rent. So instead of going back to the lease agreement and reading the provisions of this particular lease agreement, I think my ego got the better of me and was comfortable with the content of the lease agreement without reading it. And I sent this cancellation letter on a Friday afternoon, and I felt pretty proud of myself. I'm like, yes, that is the type of client service I give. I'll do a very quick letter on a Friday afternoon. So the Monday morning, I walked back into the office, very proud of myself, thinking I'm the best attorney in the world, giving this kind of service. I'm going to start drafting my eviction application immediately. But when I opened my mails, my Monday was a bit more blue than I expected it to be. And the reason was, I got a letter from the tenant's attorneys accepting my repudiation with their trust account details with a damages claim against my client, again, my biggest client here, for 1.7 million rand, because it's an engineering company, and for them to move the equipment based on the repudiation of the lease agreement, they will suffer damages to the value of 1.7 million rand. Now, I don't know about you, but you start your Monday morning with breaking the news to your client that you accidentally dropped them in a repudiation, And our damages claim for 1.7 million rand is not really the best way of starting a Monday. Long story short, luckily I was able to talk myself out of that one. But if I wasn't lucky enough to talk myself out of that one with an opponent that was willing to hear me out and help me out on that, I could have dropped my client in a very big drama position. So why I'm telling this story is I think it's very important to understand that when you act on behalf of your clients and you cancel on behalf of your clients, to be extra careful when it comes to cancellation. Make sure by the time you send your cancellation letter that you are in fact in the correct time frame to do that, and that you are comfortable that you are allowed to cancel in that way at that time. When you cancel in terms of the Consumer Protection Act, 20 business days, guys, remember the way we count days, civil method, first day out, last day in. So make sure that you only send your cancellation letter on day 21, and make sure that you didn't accidentally miss a public holiday here or there, especially now in lockdown. I don't know about you, but last week, Tuesday's public holiday came and went for me. I didn't really even see it coming. So make sure you don't accidentally miss a public holiday, because that's not a business day. Premature cancellation will definitely drop you in a situation where you're potentially going to repudiate. If you accidentally do a premature cancellation, you can still withdraw that. But the moment the other party accepts your repudiation, you are unfortunately in a very unfortunate position where you did repudiate on behalf of your client, and it's unfortunately a really big problem to get around. Luckily, your client can say, but I didn't instruct you, and you can get around, but you don't really want to do that. Chances of keeping your client happy after that happened is pretty low. So something important here, just want to close my screen there. Something very important is when you get to the point where you can cancel the lease agreement, your cancellation has to be a separate notice. I've said that earlier, but something quite crucial is on your cancellation, please make sure you do it in a letter. Please, please, please don't do it in a summons. Make a note this big. Don't do your cancellation in your summons. Don't do your cancellation in your application. The reason why I'm saying this is when your cancellation forms part of your proceedings, it means the moment your cancellation now falls in dispute, your entire matter is in dispute. Everything that you go to court with is in dispute, but even more so, you can't quantify your damages here, because now the problem is you can always claim rent up to the point of cancellation. But from the moment of cancellation until the person is out of the premises, you can't claim rent. You can only claim holding over damages. So now it's a difficult quantification on your summons, on your claim for rental. So I will explain this in more detail tomorrow, but how I prefer to do an eviction is once you get to cancellation, you send your cancellation letter. Please make sure that you tell the tenant to vacate immediately on cancellation. There is no requirement in any law, in any act, in anything that says we need to give a tenant a certain time period to vacate the premises from the point of cancellation. There's a lot of attorneys with a lot of opinions around this, and in all of my days, I haven't seen something concrete that convinces me that there's anything that requires us to give time. Actually, quite to the contrary. My advice is that, remember, if you cancel the lease agreement today, it means they are in illegal occupation today. If you give somebody, say, a month, a week, whatever your heart desires, to vacate, you are creating a new right of occupation. And while you're creating a new right of occupation, that right of occupation will have to be cancelled again before you can commence eviction. So we just went through this entire 20 business day process of getting to cancellation to just give somebody a right of occupation again. It's a little silly in my head. So make sure you don't do that. If you cancel, and you say you are immediately in illegal occupation, you are to vacate the premises immediately, and they don't. You can commence your eviction proceedings immediately. However, if you then commence your eviction proceedings and the tenant then says, listen, I will vacate in a month. Fabulous. Cool. Get that in a settlement agreement, get it in writing, and hold off on your litigation, or agree to stay your litigation, or my advice, carry on with the litigation. And if they then do vacate as they agree, then you can stop your litigation because they are out. The problem with evictions currently is, guys, we are struggling because evictions are definitely taking much longer right now because the courts are overly congested. I mean, they were already congested, and now we just had like a 3 months pause as well. So it's pretty congested. Do not take your matter off the roll, or do not remove your matter from the roll. Definitely do not withdraw your proceedings until such a time that the tenant is actually out of the premises. I'm talking about tenants, but I'm talking about all illegal occupants. The moment they are in illegal occupation, demand that they vacate immediately, because you're going to create a new right of occupation, which is the last thing that you want to do. Alrighty, I'm so impressed with my keeping time. Once again, if you guys were on a seminar with me in real life, you will know I'm horrible when it comes to time. I talk way too much, but I'm doing good apparently on a webinar, but it's sadly because you can't talk to me. But now I'm going to open for questions, but I don't want us to talk about evictions today at all, because it's not going to help us any if we talk about evictions. But we need to talk about lease agreements. We need to talk about rental collections. We need to talk about cancellation and potential things around that. So practically how we're going to do this is, let me figure this out. If you have a question, I do have a good half an hour available for questions. And like I said, if you have more time, we can do that. But let's try and keep it to half an hour. So to be aware of time and see that we can give each other enough time, please don't tell me the full story about your case. If you have a case that you want to discuss with me, you are always welcome. While you sit with your pens in your hand, you are always welcome to pop me a mail. My email address is Silna, C-I-L-N-A, at sslr.co.za. And like I said to you, if you look at the firm's Facebook page, my personal Facebook page, but basically everything I've ever said is recorded and everywhere on social media. So most of your questions will be answered by a million recordings that's on on SSLR's YouTube page, on SSLR's YouTube station. But you're always welcome to pop me an email. So let's keep the questions to factual provisions in law, because if we have to share the full fact sheet with everybody, and it's like one of those cases that's going to take 20 minutes to explain, rather pop me a mail on it. But I think it's very good discussion. So how we're going to do it is, it's going to be like nood vir nood now, nee? The one that's quickest on the draw, on unmuting your mic and you start talking, you are winning. Luckily, we've been appearing over Zoom in court, and we are all now used to being the quickest one to jump into the conversation. You can also raise your hands, but that is, I'm not going to know who's going to be quicker. So hit me with any questions.
Good morning.
Good morning.
Good
morning. Oh, just repeat that. The sound was quite intense. Somebody was almost quicker on the draw than you there. So if you can just start your question over, please.
I just wanted to ask, what would happen, let's say, after you give the tenant a cancellation letter with instructing them to evict, to leave immediately, but they decide now to remedy their breach and they pay the full amount of the rent. What do you do in such a case?
Brilliant, thank you. So that's one of my favorite situations, where you've placed the tenant on terms, he hasn't remedied his breach, you've cancelled the agreement. Regardless of when you ask the person to vacate, like I said, it's ideal to ask him to vacate immediately. But cancellation and when he has to vacate are luckily two separate things. So from the moment of cancellation, cancellation can't be undone by remedying of the breach. So basically what you do then is you send an email to the tenant saying, hello, thank you so much for paying the full arrear rental and the money that's due and owing to my client. However, the agreement has already been cancelled. So we're going to appropriate this money that you've paid towards the money that you owe our client. Unfortunately, the contract remains cancelled and accordingly you are now paying for your own eviction. Thank you very much. I suggest you end an email like that with a smiley face. So you are still, cancellation is effective. It can't be undone. The only way the parties can deal with a situation like that is once cancellation occurred and they do, the tenant does pay the full arrear rental and the landlord is happy to conclude a new agreement. You're going to do either a reinstatement addendum and you're going to actively reinstate that contract, or if you do not do that, you can conclude a completely new lease agreement. In those circumstances, because we know the tenant isn't the best quality tenant, well, shame, stuff could have happened. So I might be overly nasty to this poor person. But if it's usually a bad paying tenant, you might want to rather advise your client to stick to a month-to-month agreement than to specifically exclude the provisions of the CPA, which will allow for a quicker cancellation should the tenant then in future be in breach of the lease agreement again. Good. Pleasure.
Hi, Sona. I'm not sure if you can hear me.
I can.
So what happens where it's a commercial agreement and you send a breach notice to the tenant saying that they're in arrears of X amount, and they respond acknowledging the amount that they're in arrears in, but then they give notice of canceling the lease, and the lease agreement itself doesn't have a provision for notice of canceling the lease before the end of the period.
The tenant?
Yeah, the tenant. So the tenant responded to the notice by acknowledging the amount that they owe, but then they said that they'll pay the amount and they intend to cancel the lease before the end of the period. Is the notice of cancellation a termination of the lease, or is there an extra step required for the lease to actually be terminated?
There's an extra step required. So unfortunately, this tenant feels like he's pulling a bit of a move there because most of your commercial lease agreements, you won't be able to cancel without running into like a major damages claim or a very big penalty, because most of the times your commercial lease agreements are for a much longer time period. So your cancellation, and especially now where we know finding new commercial tenants is going to be a very painful process. So the tenant is trying to get out of that. Unfortunately, he still doesn't have the right to do that. He remedied his breach, so he's stuck to that agreement. Unfortunately, he can't, unless the lease agreement allows for it, the tenant can't get out of this one. Guys, for everybody else, I just want to clarify, we're talking about a commercial lease agreement. So if it was a residential lease agreement, obviously, very different situation. But shame, this poor tenant, his other option was to just not pay rent, and then the lease agreement will anyway be cancelled, but he's going to be in for the same damages, whether the landlord cancels because of the breach or whether the tenant cancels. Either way, the poor man is going to be in for breach, so in for damages. So my recommendation to that client would be negotiate with the landlord. I think we're all sitting currently with a lot of instructions from tenants trying to get out of lease agreements because their businesses failed. They decided to carry on working remotely, and things like that. Unfortunately, depending on your lease agreement, commercial lease agreements are very well drafted in most cases, and you won't be able to get out of it. Also now with the lockdown restrictions to a point where most businesses can trade, all your Vismail options, your causa fortuitus, all those options that we had to push for cancellation or rent reduction is out of the door. So unfortunately, that tenant is a little stuck there.
Sure. Thank you.
Pleasure.
Hi, Silna. Can you hear me?
I can.
Hi, this is Martin speaking. Thank you for the lecture today. Silna, my question relates to unlawful evictions and unlawful attachments. By the way, unlawful eviction in terms of a residential lease, as well as unlawful attachment of property without court order, but in the context of the COVID lockdown with the Disaster Management Act regulations. What interplay do you have there? And if you have a client who is a tenant in such a situation, what sort of approach would you recommend, and damages, claims, and things like that? I mean, it seems like it's just a mess with the legislation and everything that's overlapping at the moment.
Yes, it really is. I'm glad you're asking the question, because it is happening quite a lot currently with landlords doing the funniest things, and it's weird, especially for me, who's been acting exclusively on behalf of landlords for the better part of 12 years. It's such a weird thing for me to suddenly advise tenants as well, but I think it's really necessary. So the truth is, remember, any contravention of the lockdown regulations is a criminal offense in terms of the Disaster Management Act. So it's really, and I'm not being dramatic, seriously, it's 100% in line with pulling some of the other shenanigans while we are in the middle of war. This is the type of contraventions that we are talking about. So my recommendation is not to just go to the police and report this, because you don't really want the landlord to go to jail for this, because the type of crime that we're committing here is one of those that will take your visas away. You're not going to, even if we can travel again in 3 years from now, they're not going anywhere. So we might not want to really do that. My recommendation would be a very stern letter to the landlord explaining the criminal offense that they are committing, the severity of the criminal offense, allowing him time to stop doing whatever he is doing, but telling him that unless he fails to do that, you will have no choice but to report this to the authorities. Make sure that your wording of that letter doesn't have the slightest hint of extortion. You don't want to extort somebody in putting if you take a gun out, and this is a pretty impressive gun, if you take this gun out, you need to make sure that you use him perfectly. So you need to say, listen, dude, this is not just your normal arbitrary evictions, your bad behavior. You need to comply with the regulations. Otherwise, we will have to report this to authorities. If he doesn't comply with that, unfortunately, an urgent application is going to be your only option for an interdicting the landlord from doing this. I think we've seen more urgent applications than we ever have. And the courts are quite keen to grant urgent applications, urgent relief for tenants that's been spoliated or things like that, the deprivation of full freedom of the use of the property, things like that. The courts are hearing a lot of urgent applications. I basically think that's all the courts are doing currently. I'm dramatic on that. It wasn't real.
And Silna, just to ask you on that, I'm a candidate attorney, so I'm still learning. Forgive me if this is a very basic question, but
no,
could one ask for damages or special damages in such an urgent application or not? Or is the urgent application strictly for the spoliation, and then the tenant would have to take up further legal proceedings down the line in respect of damages?
It's a brilliant question, and I don't think it's a candidate attorney question, to be quite frank. I think there's a lot of practitioners that will benefit from the question. So remember, your urgent applications are always for a spoliation application. You can't claim your final relief, for instance, damages, things like that, on an urgent basis. And so what you will do is you will have a two-part application. Your urgent application will only deal with the urgency of the matter. So an interdicting the landlord from carrying on with his shenanigans. It's a new legal term, shenanigans. So that is an interdict right there. Potentially an order ordering the landlord to return undisturbed use and enjoyment of the premises, reconnecting electricity, whatever the situation might be. And then part B will carry on in normal course, and part B will then be around your claim for damages and for things like that. So it will be in a separate part of your urgent application, and that will run in the normal course. But on that topic, you get amazing cost orders in urgent applications, because there's usually, we usually don't brief counsel, but you get your cost orders are absolutely gorgeous, because it's on an urgent basis. The judge, by the time you get there, isn't really pleased with what's happening in front of him. So your chances of getting a cost order, if you can definitely show your urgency. Remember, the problem with urgency is, unless you strike immediately, you lose your urgency, especially on spoliation, quite quickly. If you try and convince the court of urgency after the tenant hasn't been in possession of the premises for about a week, the court's going to say, okay, it's been like a week. How is this suddenly urgent? So just make sure you don't lose your urgency in any way, and make sure you still draft properly. This is always my advice on urgent applications. I've seen opponents draft horribly on urgency. I swear suddenly the punctuation and everything is out the door. They just hoy. But make sure you still, when you're busy with an urgent, make sure, even though your pleadings are going to be shorter, rather condense your pleadings, but still draft a very good quality pleading. No judge wants to read something that's not properly punctuated. I clearly have an issue with punctuation, so it's very important that help at all.
All right. Thank you very much.
Pleasure. Right. Do we have anything else? Your connection sounds interesting, unless you are calling from the International Space Station.
Today. Can you hear me?
Unfortunately, we can't, but yes, what we're going to do. Don't you please want to pop me a mail, and then I will bring your question into tomorrow's session. Can we do that?
Okay, I will do that. Thank you very much.
Well, now I can hear you. Look at that. That is karma for you. Murphy,
yeah, no.
Other one.
Great, thank you.
Good. Anything else? I mean, anybody else? Any other questions?
Hi, Solna.
Hello.
Can you hear me? It's
Yes.
Shelley from Johannesburg Attorneys. We're actually your correspondent attorneys in Cape Town. We do quite a lot of work for SSLR. Just a quick silly question. I didn't get something that you mentioned earlier.
Yes.
Regarding the standard lease that you have, that you say a lot of magistrates and judges are fair with, what you referred to a name and I didn't get it. What is it called?
The TPN leaseback lease. So TPN Tenant Profile Network. Their leaseback. So you can go onto the website www.tpn.co.za. It's an annual sign-up fee that you pay, and it's for unlimited use.
Super, thank you.
And thank you for being brilliant correspondents. If you guys need Cape Town correspondence. Thank you. Brilliant. Anything else? All right, guys, let's. Ooh, somebody has a question.
Hi, Solna.
Hello.
Can you hear me?
I can.
Okay, you're speaking to Duncan from Rogers Devachanda Attorneys. And my question is, so let's say the lease has been terminated and the tenant's already vacated the premises. So now there's outstanding rental and there's damages to the premises itself. So broken doors, windows, so on. So the landlord had a there's a deposit that they're holding in an interest-bearing account. Is it lawful to offset the deposit against the damages to the property and then just bring a claim for the outstanding rental? Because it's easier to claim rental than it is damages, which has to be quantified and it's going to be in dispute.
That's a brilliant question, Duncan. So the thing is, it depends on the lease agreement. On the one hand, if it's a residential property, the Rental Housing Act deals with the utilization of a deposit in a lot of detail. You are definitely allowed to appropriate your deposit towards unpaid rent on cancellation of the lease agreement. Regardless of what your lease agreement says, you can always use your deposit money for unpaid rent at the end of a lease agreement. However, now the tricky part comes in, the damages. So your damages was so dramatic, I must say, and I thought I'm the dramatic one. Broken doors was quite something. Broken windows I can work with, but I haven't seen too many broken doors in my life. But broken doors, broken windows. The only way you're going to be able to claim those kind of damages from your deposit is if there was a proper ingoing inspection done and a proper exit inspection. Because the problem is, a lot of landlords doesn't do full and proper ingoing inspections. So the state of the premises is almost impossible to prove by the time the landlord, by the time the lease agreement ends. So let's take the door, for example. If there wasn't an inspection showing that all the doors were like 100% and they were opening, closing, and they were actually full doors, how would you be able to prove that those damages were caused by the tenant? So if you have a proper ingoing inspection signed by both parties, and then an exit inspection, all those damages you can claim from the deposit. But your question wasn't that. Your question was, can you appropriate that towards the unpaid rent? Yes, you can, or to the damages. How you quantify that and which part you claim is really up to you. I see what you are saying in rather claiming, rather deducting the damages from the deposit. A place where that would be quite handy is if you want to utilize your rent interdict summons. You obviously, for a rent interdict or perfection of your landlord's hypothec, you can only claim the portion that is actually rent. But in after that, whether you, once the lease agreement was cancelled, the people already vacated, there's not really anything in law that would make it easier to claim one kind of thing, be it damages or rent, from that. Because if you want to deduct your damages from your deposit, in terms of the Rental Housing Act, you anyway need to be able to provide proof of your incoming inspection, your exit inspection. You need to be able to provide the receipts of the damage repairs that you've done. So honestly, between you and me, to claim damages is actually a bit trickier thing, but not damages, damage to the property is actually a little bit trickier than claiming your rent, because claiming damage from your deposit has to be done in terms of the Rental Housing Act, where claiming rent is just done in terms of your lease agreement. Am I making sense in any way?
Yes, that makes perfect sense. And I do advise my clients on an interim inspection report and an outgoing. So that's
brilliant.
Perfect. Thank you.
Pleasure.
Hi, I just want to know if after you've done the letter of demand for rental payments that's outstanding, and the tenant pays a part payment, do you need to give him tenants? How does that affect your letter of demand and the right to cancel?
Beautiful question. Thank you. Very important. Your letter of demand, your MURA letter, says that the tenant has to, well, should say that the tenant has to remedy his breach in full within the 20 business days time period. If he doesn't, you can cancel the agreement. So even if he short pays by 100 Rand, I'm dead serious, 100 Rand, 50 cents, whatever, if he hasn't remedied in full, you can still cancel. So basically you do what I said on the payment after cancellation. You accept that payment, you say thank you very much. However, there is still X amount outstanding, and either you need to remedy that in full. So that's still outstanding. You still have this time period, call it whatever, 2 or 3 days that's still left. If you don't pay that, I'm still going to cancel. Or, but you're not going to send a new letter of demand. Remember, the moment you send a new letter of demand or terms letter, the time period is starting to run all over again. So don't send a new one. Confirm receipt and say that they are still outstanding and the time period still runs. If they don't remedy in full, you can still cancel completely, and you can proceed with eviction on that. So that's a relatively important thing, and it happens quite often. If you do not phrase your letter of demand to say remedy in full, then suddenly we can be open for dispute. So make sure you use the words in full by paying the full outstanding amount to avoid any confusion there. Happy with that?
Hi there.
Yes, thanks.
Hello.
Brilliant. Hello.
Hi there. So I just want to inquire about something. I've got a situation where a tenant is involved in criminal activity, and the landlord actually went in with the police and witnessed the tenant taking substances which he shouldn't have, and the police.
You're just being so diplomatic about it.
Yeah, and the police actually said to the tenant, well, they must just do it quietly. So the thing is, I think
said to the tenant.
Yes, no, don't worry. The landlord has actually is going to report it to the station commander. The landlord is using, I think it's your lease agreement, and it states there that criminal activity can be. Yes, okay,
That's
can be
fine.
cancelled. So this poor man's trying to keep everyone happy, but can he just proceed, cancel, and ask them to vacate?
So I'll tell you a little fun story. This is the
Okay, thank
first
you.
time in the past 6 years that I have had somebody actually considering using that clause in my lease agreement. So I'm very happy to hear that. I think when you read it as well, you thought, this feels like a little bit of a grey clause. I don't easily draft grey clauses, but the reason why I've done it, so just to put everybody else in the picture, the clause reads that if the tenant is committing, or if the landlord or the agent or anybody suspects that the tenant is committing any crime in the premises, then the landlord would be allowed to cancel the agreement with immediate effect, but he will have to be required to report this to the police, but he doesn't have to prove that because he can report anonymously. So the reason why we have that clause is I've had too many cases where the tenant is cooking meth in the kitchen, or the brothels. I've seen way too many brothels in my life. And they're committing all sorts of crimes in the premises, and we need to be able to get them out of the premises without, how do you place somebody on terms to, stop cooking meth for 20 business days? Lekker. I mean, it just doesn't make sense. Or you can't have a brothel for 20 business days, but then we're going to, how do you prove these things? That's why I have a clause like that in the TPN leaseback. And my assumption and sort of the premise on which I did it was always, if you are cooking meth in the kitchen, if you have a brothel, you sort of know when you're doing illegal things. I've never cooked meth and I've never had a brothel, but I suspect that if you do, it's not something you accidentally do. It's not like, oopsie, you didn't know you're committing a crime. You must know when you commit crimes. And if there's a little bit of pressure and the landlord then wants to cancel, the chances of somebody disputing that clause is pretty much slim to none until this webinar, which is now a very exciting thing that happens. So to be honest, I do not believe that the clause would be enforceable just in the way it's written, simply because if the tenant says he is not committing a crime, then we're going to have to prove that first. But now the problem with the police saying that the tenant should just use his meth quietly, I mean, like, that's the weirdest thing I've ever heard in my life. It does cause a bit of a problem. So I would rather then move to a letter to the tenant saying that if you do not cease with your activities or agree to cancellation, I think you want to get to an agreed cancellation. So maybe tell the tenant, listen, you take your stuff and you move and you go use your meth quietly somewhere else on the instruction of the police, but please do not do this in our premises, or for that matter, rather than place him on terms, giving him full 20 business days to remedy. If he doesn't, and say in your letter of demand that if there is any future complaints about criminal activity, you will cancel the agreement immediately. I do think that is a safer, more foolproof way of using that.
Thank you very much.
Does it make sense in a way?
Yes, it does. Thank you.
But thank you so much for entertaining me on my own clause. That was good. Good. Do we have anything
Silna,
else?
I've got one more question. Sorry, just based on what one of the other attendees asked. In respect of exit inspections, if an exit inspection is not done within the stipulated period, I think it was 3 days or something like that, and the landlord still refuses to give the deposit back to the tenant after they've moved out, there was an article that I read or something I saw about certain conduct being criminalized like that as well. What is your stance on that? Is it just a civil claim, or would the landlord in such a position also be foul of any criminal offenses?
So your criminal offences is only very specific parts of the Rental Housing Act, but that is like your arbitrary evictions, things like that. Unfortunately, or fortunately, goodness gracious, otherwise all my clients would have been in jail by now. The part we'd go relating to deposits, inspections, not criminal, so only a civil matter. But a tenant that doesn't receive his deposit back, my advice is actually always to go to the Rental Housing Tribunal. Personally, I'm not a fan, and I will say that, and I've said that while I know that I have tribunal commissioners in my seminars. I'm personally not a big fan of the tribunal, simply because they do not have the jurisdiction to grant eviction orders. And a lot of people believe that they can obtain eviction orders through the tribunal. But when it comes to rental claims or deposit claims, the tribunal is the perfect place to do that. Reason why I'm saying that is your client can do that without you, which is sort of, okay, we're not getting fees for that, but then at least also we don't have to go to the tribunal. So win-win in a way. Client can do it for free, and he can usually get a result in about 3 months or so. So it's a quicker process, or your other option is obviously to issue summons depending on the value of the deposit that you are talking about, but definitely not a criminal offense, not the inspection part.
All right, thank you.
Pleasure.
Hi.
All right.
Can I
Yes.
ask one question? I know your time is up. My name is Nafisa, and I did 2 years of law, but anyway, I took up a lease agreement with somebody who uses your invoices. Maybe he's using your lease agreement. But anyway, the thing is, he wants to come all the time. I had a 6-month lease agreement, all the time to view the property with potential buyers. So in the lease agreement, he's got there that he needs to give me 24 hours notice, or in an emergency, if he wants to bring somebody, he will phone me telephonically. And he's been bugging us the whole 6 months. The lease agreement just ended. And can he now bring people in lockdown? Because they forcefully, our gate was open. His wife brought somebody in during stage 4 lockdown, demanding to see the premises.
No. And that is in contravention of the lockdown regulations as well. So the contract has ended. You say the contract's ended, hey?
Yes, and he said
So
that
you
we
are
work
going to
on a
vacate.
month. Yeah, we're still there because, but anyway, my kids are there. I'm out of the country. They're with my mom. So the thing is, can he still continue this now in lockdown 3?
Well, the thing is, remember your lockdown level 3 regulations doesn't limit anything on viewing properties. Property viewings are definitely allowed. So it doesn't sound like there's anything that's illegal, but it will depend on the content of the lease agreement. I must say, emergency viewing is not something you hear about every day. I don't think I've ever been in a situation where I thought, oh, if we don't do this viewing immediately, somebody's going to die. Emergency access to premises will only have to do with maintenance, so a geyser that bursts, something like that. So usually a lease agreement is supposed to make provision for specific viewings. So say every second Sunday as an open house. Open houses at this stage is a bit of a problem under lockdown level 3, but it's not illegal, but it's a bit of a technical process. So I would rather recommend that you do a letter to him or an email and just say, listen, let's agree to a certain amount of days that people can come over and view the property. But to be honest, my recommendation would rather be to find an alternative place, because I don't think this landlord is obviously desperate to sell, so he's going to show the property as much as possible. Unfortunately, what he's doing doesn't sound to be illegal, but if you feel that it's in contravention of the lease agreement, like I said, the Rental Housing Tribunal is your best bet.
Okay, and
Alright.
just one more question. He says now we work on a month-to-month basis. So I am going to continue with him. I should just send him a letter. That's my best bet, you say?
Yes, or the tribunal if that doesn't work.
Okay.
All right. It's a pleasure. It's not often that I have to give advice to somebody while I have like 105 other attorneys witnessing my advice here. Were you guys happy with that advice? All right. Guys, let's do this. I know there's still a lot of questions, and especially because we don't have like that fun lunch situation that I can sit with you and have lunch and talk about the things. And because I must say 5 hours is quite a short period of time for me to get through all the work, you are really, really welcome to pop me an email so I can address some of the questions during tomorrow's session as well. But my recommendation is definitely please go watch the YouTube clips that I've referred to, the Ubuntu things. There's going to be a few others that's going to be entertaining. Also, every Wednesday evening from 6, I have this interesting channel with 2 other eviction specialist firms called the Property Law Alliance. It's on Facebook. And every Wednesday we talk about these things, and we deal with rental questions and eviction questions and things like that. So you're welcome to watch that tonight as well. I think there's going to be a few interesting things we're addressing. Welcome to do that just for some extra things. But pop me a mail if there's any specific questions now. I'll address it during tomorrow's session. And tomorrow we're going to go into evictions. So make sure you eat a proper breakfast in the morning, because tomorrow is going to be a pretty technical session. I will show you the way we're going to draft. I will show you actual drafting. I'm not going to work too much on my slideshow tomorrow. Tomorrow we're going to practically look at drafting, way we draft and the way we practically get our evictions done. I've sent you pleadings as well as part of the study material. So go through that, sort of prepare a little bit. And if you have questions, even if you wake up at 3 this morning and think, oh, I have a question, please pop me a mail. I'll either send you an email back, or if it's something that I think everybody can benefit from, I will start tomorrow morning session with a few questions. So again, my email address, Silna, CILNA, @sslr.co.za. You're welcome to pop me a mail. And I am really looking forward to seeing you guys tomorrow morning, again, starting at 10. And it's probably going to run for the same time, and we will do all things evictions tomorrow. So sleep on what we've said, and then I will see you guys in the morning. And remember to wash your hands and wear masks.